Good evening and welcome to the Modification Record webinar. Tonight we're going to be discussing some of the different modification types as well as a recent update to the Los Angeles Municipal Code, which allows for folks to relocate their proposed business premises address through the abandonment and refile process, as well as implements the new equity share component, which allows for individual social equity applicants to aggregate their ownership to meet the 51% equity share requirements. So tonight we're just going to do a basic overview of the different records and what types of modifications can be submitted through those records. We'll show you a picture of the portal and then just make sure folks are using the right record number based on the modification they're trying to make. We'll briefly talk about the DCR licensing map and some of the different layers there and how the map can be utilized and how folks can use the map to try to determine which areas are or are not subject to a finding of undue concentration. We'll take a brief 5-minute break and then we will hop into the question and answer section. With that, can we go to the next slide? So the newest record we've created is our legal business entity record. This is a record that now houses all of the owners, the primary personnel, the authorized agent for the business, all of the organizational documents for the business, and it allows DCR to complete the equity share review. This type of record allows for the equity share review to be completed separate and apart from the application, which was intended to allow social equity applicants to get their business entity vetted, so that when they do decide to submit an application, the focus for that application will really just be on the proposed business premises, the premises diagram, attestations, and indemnification agreement. The benefit of this record is twofold. One, for folks that already have a legal business entity and know that they're going to be applying for an activity that's subject to equity share review, they can engage in that review prior to submitting their application to the department. And then for folks that will be pursuing other activities, it will also reduce the cost for the review for those activities. So for the legal business entity record, now that we're doing this review outside of the application process, it's no longer going to delay application processing nor impact our ability to issue temporary approval if there is a pending modification request. Any modification that updates the owners will effectively, once it's processed, get pushed down to any of the pending applications or licenses issued to that business entity so that the information is succinct and straightforward. Since the owner's primary personnel authorized agent are being handled on this legal business entity record, which is a living record that could be modified over time, there's no need for us to create a new application record anytime that there's 100% owner change on an entity where the entity itself is not changing, which is an important note for folks, is that legal business entity record will have to be modified and maintained as things change within the company, whether it's owners coming in, new shareholders that meet the definition of owner, or primary personnel within the entity are changing hands. The ease of using this and doing modifications against this record, of course, are to reduce the impact on the application, whether it's temporary approval or annual application processing, and any operational disruption. Prior to the creation of the legal business entity record, DCR would basically create the application to reflect the new ownership that required the new record. We would keep the old record open, and then when they were ready to finish processing the ownership modification, a cancellation request would be submitted for the original record, and then we would cancel that record, and then we would grant temporary approval on the new record. So this process is a lot more streamlined. It will save time and money for the applicant, as well as reduce processing times for applications that are before the department. It will also reduce fees associated with the need to modify multiple records for folks that do have either multiple locations or they've submitted for additional commercial cannabis licenses under different record numbers. Next slide. Can we, perfect. So the next record that I'm going to talk about is the pre-application review record. This is a record that cannot be modified. The purpose of the pre-application review record is to determine whether or not a proposed business premises meets the land use requirements of the city. Is it properly zoned? And is it properly distanced from sensitive uses? If the proposed business premises is eligible for further processing, of course, the pre-application review record is updated to eligible for further processing. And then the applicant or prospective applicant has up to 1 year to submit their application record. If an application record is not submitted within 1 year, the pre-application review record just naturally closes out. If you lose site control or you're never able to gain site control, you're unable to come to terms with the landlord, you may submit a business premises surrender form, which will result in the abandonment of the record. For folks that have been selected as part of phase 3 retail round 1, phase 3 retail round 2, the abandonment process enables you to refile either within the same community plan area and now under the amended law in a community plan area that has not reached undue concentration. And we'll talk about the licensing map and the different layer on the licensing map a little bit later in the presentation. If you are submitting your proposed business premises and you're eligible for further processing, but you've applied for an activity that's not subject to a finding of undue concentration, you can just withdraw your pre-application review record and submit a new pre-application review record once you've identified a new proposed business premises location. The review is site specific, so there is no information on the pre-application review record that can effectively be replicated or used for a new proposed business premises location. The land use review, the mapping review for sensitive uses is all unique to the parcel that you've proposed. And unfortunately, we're not able to transition that information to a different parcel because of course, each parcel is unique. So no modifications allowed for pre-application review records. For folks that have the opportunity to apply for a retail license with on-site sales, if you surrender your business premises form or you submit the business premises surrender form, we can abandon the record and enable the refiling. And then of course, if you've gone through this process, your phase 3 retail round 2, for instance, and you've submitted the pre-application review record, we can always roll back your lottery record to enable you to submit the new proposed business premises record through the pre-application review process. The way that folks can refile is the same, and that's not changing. Basically, when you refile, you will submit the updated information form. And if you are proposing a different premises diagram or a different entity, you would just list that new information on the single form. And then when we review the refiled record, we will update the record in the back office if we're eligible to make updates to the record at that time. There's different rules for general businesses. There's different rules for a social equity record with a single social equity applicant owner. And then of course, for social equity records that have multiple social equity owners to meet the 51% requirement, that has to be refiled, of course, as the same entity. And the social equity individual owners, of course, would be the same for that entity until the legal business entity is updated. Next slide, please. With the modification to how we collect information from applicants, there's very little information that is now going to be stored on the temporary approval application record. That record will focus on the business premises lease, which is not required during the pre-application review phase. Again, if the land use review was previously completed and you're ineligible to move forward at the location. Once you submit the business premises surrender form, we would be in a position to abandon the record, and then you would have the opportunity to refile the record according to the municipal code rules. An abandoned record that has been refiled is not eligible for further refiling. So for folks that are in phase 3 retail round 1 or phase 3 retail round 2, it's really important that if you don't have site control, you let the department know so that we can roll back your original record to allow for a new pre-application review record to be submitted. And you should only be submitting your temporary approval application or at some point annual application once you're ready to move forward with the location, which means you've gained site control, you have the ability to submit the proposed business premises diagram, the indemnification agreement, and then the associated attestations for your entity and for that location. All of the ownership, equity share review, that is handled on a completely different record. So it reduces the documentation that has to be reviewed through the application process. It will shorten application review, and it also reduces what can be modified on the record. So given the fact that the indemnification and the attestations are all entity and site specific, as well as the land use review and the proposed business premises diagram, if those things are changing, you'll have to submit a new application record. You can't modify that until a license has been issued. Next slide, please. Once temporary approval has been issued, temporary approval is definitely a form of licensure at the local level. Now, DCR has always accepted relocations within the same community plan area since we were able to re-accept modification relocation request. On-site retail and cultivation are geofenced to the community plan area where the license was issued. DCR did submit a proposal to allow licensees to relocate to a community plan area that has not reached undue concentration. That recommendation was not adopted by the Planning and Land Use Management Committee or the City Council. So that recommendation is still pending in the Plum Committee, but unless and until it is adopted and the municipal code is updated, on-site retail and cultivation can only be relocated within the same community plan area if it's associated with a license. Updated business premises diagrams can be submitted as part of the temporary approval process. Folks go through tenant improvements. They rearrange how they're utilizing licenses. You may want to do an expansion of your cultivation footprint. You may add different activities at the location, which would necessitate the rejiggering of your business premises diagram. Of course, once you've been issued a license, you'll have the ability to submit those updated business premises diagrams against the record. If we review the business premises diagram and it results in a square footage change of more than 2,500 square feet or 20% of your existing footprint, whichever is larger, then it would be considered a relocation, and then we would process it through the relocation process. Indemnification and attestations can be updated as owners change because they are started on the record. And then of course, once a license has been issued, DCR does have the ability to consider an entity substitution request. For the entity substitution request, the entity that you're proposing to allow to take up that license opportunity does have to have a legal business entity record. So if we deem it eligible for further processing, we can create the application record for that other legal business entity, and then they can move forward with the process of meeting the requirements on their own. And once, of course, they meet the requirements for licensure, then the original entity would submit their cancellation documents to the department. We would cancel the original license issued, and then we would issue a license to the new entity. Next slide, please. So once you've logged into the DCR licensing portal, you can navigate to submit a modification request. You can see on the little subject bar, there's a button called submit a modification request. If you click on that, it will take you to the a general disclaimer screen. Once you've read and accepted the general disclaimer, then will actually allow you to begin the modification request. Next slide, please. When you get into the modification request, and this is the first page of that, you will have to enter the record ID number that you're seeking to modify. So if you're looking to update owners or primary personnel, add an authorized agent, you're going to need to do that through the legal business entity record. So the LA-B record, that would be the record you enter there. If you enter that record, then it will verify that you're a contact on the record and you're eligible to submit the modification request for the entity. And then it will give you the opportunity to select an ownership, primary personnel, authorized agent type of modification. If you're looking to update and modify your legal business or your temporary approval license, of course, you would enter the corresponding record number. Please make sure that you're using the most current record number for anything where a license has been issued. As folks know, we just went through, or we're still at the tail end of the 2023 renewal process. So if you try to submit a modification request on your 2022 record and you've already submitted the renewal and have a 2023 record, one, if we didn't catch it and we applied the mod, it would only get applied to your 2022 record, which of course expired on December 31st of 2022. So that won't effectuate any changes on your 2023 record. So if your analyst is telling you, hey, we need you to either submit an updated modification request or we need to link it to a different record number, it's to ensure that the modifications get applied to the correct record number and that they would be visible on a go forward basis. It doesn't get applied to a retroactive record. And again, with the advent of the legal business entity record, the ownership modifications and some of the things that may take more time because they require an additional equity share review or for the analyst to go through your operating agreement, that is being dealt with on a separate record. And then once approved, it would get pushed down to any pending applications or license records. So we have had a number of questions about, hey, I entered my record ID. Why can't I make this selection? The answer is going to be tied to, did you enter the record ID that can be modified for that specific modification request? And then for any temporary approval application record or license, the analyst will have to ensure that the milestone is adequately or accurately reflected on the record because the milestone drives what options are selectable for that record type. And if I am just able to share my screen for a minute, I'm going to bring up the DCR licensing map. So as folks know, we have a DCR licensing map that lists the undue concentration limits on our website. This is a tool and it's for informational purposes only. We update the sensitive uses on a quarterly basis. They'll be updated tomorrow. I will pull the raw data from all of the different governmental websites. I'll provide it to the Department of City Planning, and then they'll spend the next week or two refreshing all of the layers and replotting the data points. For the retail storefronts and the applications and anything with the on-site retail, I'll provide them a list of the information as it exists in our system tomorrow, and they'll also refresh those layers. When you get into the map, you're going to see a couple of things. One of them is going to be the capacity summary, and then the other one is going to be an actual map where you can toggle on and toggle off layers. Within the map itself, and it's easier to see it when it's embedded, you can click on a layer list and that layer list will bring up different options. So let me just hop into a community plan area, pick Hollywood. So when you click on Hollywood, you can see that information pops up as it relates to that CPA. Within this CPA, there is retail license capacity for 20 licenses. DCR has issued temporary approval to 11 locations. So DCR has the authority to issue 9 additional licenses before undue concentration is triggered in Hollywood. Once undue concentration is triggered, any pending application would be routed to the public convenience or necessity process. And if the applicant chooses to move forward and seek a PCN finding, they submit all of the paperwork, the city council will have 90 days to make the public convenience or necessity finding. If council doesn't make the public convenience or necessity finding within 90 days, the application is not eligible for further processing and will be denied by operation of law. Because of how undue concentration is written, DCR has the ability to accept more applications for a community plan area than it can issue licenses for. To address this issue, DCR has recommended an amendment to undue concentration to have undue concentration be triggered based on the number of applications accepted, so that all of the applications before the department could be processed to licensure provided the applicant meets all of the licensing requirements. Again, that is a recommendation that's pending in the Planning and Land Use Management Committee, and it has not been adopted yet. As part of that updated language, DCR has also recommended grandfathering in any pending application that is within that community plan area to ensure that dozens of applicants don't spend a year or two pursuing a license only to find out that DCR has issued the last license available and then get routed into a public convenience and necessity process that could result in the denial by operation of law of their application record. So for folks that will be looking to relocate to community plan areas that have not reached undue concentration, you're going to need to factor that calculation into your business decision making, because if that amendment is not adopted, and Hollywood is a good case where we have more applications pending than we have the authority to issue licenses for, there could be a time where we've issued our final license in that community plan area, and every additional application will require a PCN to continue processing and ultimately issue a license for. So I expect that I'm going to get some more detailed questions about that, because undue concentration is one of those things that everybody is kind of aware of, but they're not aware of all of the semantics and nuances that go into it. So I'll probably answer a little bit more of that when we get into the Q&A. Now I'm just going to toggle on a few of the layers. If you're looking for proposed locations, it's important to understand what creates a buffer and what doesn't. So a pre-application review record and pending modification request, these do not trigger the 700-foot buffer between businesses. Under LEMC section 10502, a retail storefront location creates a buffer and effectively plants their flag upon the payment of their temporary approval application fee or business premises relocation fee. Under both of those situations, an application for that location would be before the department. Either they paid the TA application fee or they paid the business premises relocation fee, and DCR created an application for the new proposed location. So if you see the red dot, which is the pending pre-apps, you should be aware that somebody has entered the queue and has identified this as a proposed location, but they may or may not ultimately submit an application. Some folks will submit a pre-application record to see whether or not the proposed location is compliant. They may submit it for multiple locations. They may use that information to try and negotiate with landlords. At this point in time, a buffer is not created and a flag has not been planted. So if somebody else comes in, they're deemed eligible for further processing and they submit their temporary approval application and they pay their fees first, it could result in these businesses getting knocked out. The same thing goes for the pending modification request. A pending modification request may be deemed eligible for further processing, at which point we would invoice them for the business premises relocation fee. If the fee doesn't get paid, they don't get to plant a flag. They don't create a buffer from other businesses, and there's no application before the department. So the red and the purple you should be aware of, but at that point in time, they don't necessarily create buffers. We are working with Excella and the city planning GIS team to interface the DCR licensing portal with ArcGIS Online with the hope of tying our application workflows to this dynamic map so that the map gets updated overnight as records may be updated through the system. And that's something we believe will be rolled out by April or May. For pending applications, these are folks that have paid the temporary approval application fee, or they've received a fee waiver, or they've paid the business premises relocation fee. So these are locations where a flag has been planted and another business would not be allowed to propose a location within 700 feet, exterior wall to exterior wall. Of course, the retail temporary approvals, these are folks with licenses, and then we have the retail temporary approval for the social equity folks. So these are our green dots. These, of course, have licenses. So another business would not be allowed to, of course, relocate within 700 feet of this proposed location. And just a reminder for folks, retail storefront or commercial cannabis businesses with on-site retail sales are not considered a sensitive use. So when we go through the pre-application review, we're only vetting for schools, daycare facilities, drug and alcohol treatment facilities, permanent supportive housing, parks, libraries, etc. So when we deem a pre-application review record eligible for further processing, and you get the benefit of being exempted from future sensitive uses coming in, provided you submit your temporary approval application within the 1 year, it does not include other businesses with on-site retail sales. The code treats those completely different, and DCR does not have the authority or discretion to currently allow folks to be within 700 feet of one another. We are hopeful that the city council will take up our recommendation to allow businesses to be located closer than 700 feet, provided we don't exceed undue concentration and there's not more than a sufficient, a certain number of businesses within a certain radius. But again, those would be future policy decisions. And then of course, the hope there is to open up more parcels where DCR could consider issuing a license so that folks have more options available to them. For our purposes as a department, the community plan area really drives everything we do and what the undue concentration looks like. So the default for our map is going to be community plan area. If you're looking for your council office, you can always toggle on the council districts, and that'll actually show you which council member and which office would be associated with the district that you're applying for, you're operating in. So this is a helpful tool, especially if you're working with other city agencies and you need help navigating through processes. These would be the council offices that you would want to reach out to see if they can provide you support or a contact at some of these other departments. The last bit that I'm going to jump into now is the sensitive uses for commercial cannabis activities that do not have on-site retail sales, so non-storefront delivery, cultivation, non-volatile manufacturing, distribution, testing labs. You need to be worried about the schools. And you have to make sure that a school is not within 600 feet of your location. For record types that have on-site retail sales, you've got to worry about permanent supportive housing, libraries, public parks, daycare facilities, and alcoholism and drug abuse recovery or treatment facilities in addition to schools. So you have the ability to toggle on and toggle off the different sensitive uses based on which commercial cannabis activities are associated with your proposed location. And again, this information is provided for informational purposes only. Basically, we download this information from different publicly available government websites. We provide it to city planning, and basically they update the layers based on the information on those spreadsheets. When we do get pre-application review records or modification requests, if we do think that there's something within 700 feet or 600 feet of the proposed location, what we do is we click on that actual icon, and then we'll get more information about what it is. So the one I clicked on was a childcare facility. It's got the name of the facility, it's got the facility address, and then we can cross-reference that information against the list. So again, I'll be updating the list tomorrow, and then we'll push it out to the map. Information on sensitive uses is only updated on a quarterly basis. So beginning tomorrow, when folks can get their modification request in, once you've paid your modification review fee, we would be using the February 1st, 2023 sensitive use list to determine whether or not it would be eligible for further processing. And if we do see something, we'll check the facility, and then we'll make sure it's licensed and it's properly zoned for the purposes of our code. One of the things that folks have asked about, especially with the daycare facilities, is the code has never allowed for a licensed daycare in home to be considered a sensitive use. And, just to make it easier for our stakeholders to understand, is those are generally licenses that are issued on a residentially zoned property, or the business got some kind of variance to allow for a commercial license to be issued on a residentially zoned parcel. If it's on a residentially zoned parcel, it's not considered a sensitive use for DCR's purpose. If it is a licensed commercial daycare facility and it's not residentially zoned, then it would be considered a sensitive use until the facility is no longer in operation. So on February 1st, you may have a licensed location and the business relocates or it goes out of business. It's going to be considered a sensitive use until May 1st when we pull the next sensitive use list. So if it's April and the business goes out of business, it's still going to be considered a sensitive use until the information on the government website is updated and we pull the new information on the next quarter. So hopefully that helps folks as well. So that's kind of my brief overview of the map and some of the mapping tools. One of the other websites that I like to use is the Zoning and Information Map Access System. So if we go over to zimas.lecity.org, this is a helpful resource as you look for information. You can go in and type in an address, and it's not going to give me the information I want because I had street information and a code. So here on ZIMAS, you can get the north-south information by putting in the street number, street name. 221 North Fig, of course, is DCR headquarters. You've got jurisdictional information, which will tell you what community plan area it is, what area planning commission, the neighborhood council, who the council member is. If you go down to planning and zoning, you'll be able to see what the zoning is. So this is a C4 zone, so it's a commercially zoned property, and you can get more information there. If you need to identify who the local police, area station is, it's going to be Central Division. It's in Police Reporting District 121. It's got fire information as well. So this is a helpful tool. It also includes a couple of different layers. So you can come in here and you can toggle on the backgrounds, and you can actually go to the digital overview, which was last updated based on aerial views from 2017. And you can kind of use this for mapping purposes. So you can see the exterior walls of Fig Plaza, and then you have a radius map over here, and the radius tool will allow you to add different buffer distances. So we can go ahead and put in 700 feet down here. And what this does is it does 700 feet from the parcel, and it identifies any parcel that touches that 700-foot barrier. So you can see how the DWP facility across the street is within the 700-foot buffer, but then over here, a portion of the facility is outside of 700 feet. And then, of course, this is from the parcel line to parcel line. So if you were looking at this as a retail storefront business, what you can do is you can click on the closest exterior wall, and then with this tool, which is the line draw tool, you can click on a corner, and then you can basically drag it over to this other parcel. And over here, you will actually be able to see what the distance is. So here to here, and you can see it's 461 feet wall to wall. So when an analyst identifies a potential sensitive use, they're using the mapping tools within ZIMAS, which is the underlying data that we use for the DCR licensing map, to do the measurements and to check to see wall to wall between commercial cannabis businesses, looking at the parcel lines for any potential sensitive use, and then identifying whether or not, like for a daycare facility or other, whether or not they have sole control over the parcel, which means that only that business is operating at that parcel, or whether or not they're one of many lessees at the location. For instance, a strip mall may have multiple units. It's all the same parcel, but you have different businesses operating there. If it is a strip mall, there's multiple units on the same parcel. When we do the measurements, it changes it because we're no longer going to the closest parcel line. We would be going to the closest parcel line to the business that creates the sensitive use, or in some cases, it allows for us to effectively go to the exterior wall when a portion of the facility is a parking lot. So those are all important things that your analyst is looking at as they're reviewing your case files and looking at the pre-application review records. So with that, I'm going to go ahead and turn it over back to the main presentation. This ends the formal presentation. We're going to take a brief 5-minute break, and then we're going to jump into the question and answer. We did receive approximately 50 questions, and we're going to try to get through as many of those questions as possible. And I can see, and I want to thank my team who is going through the questions that are being answered as part of the Q&A, because I can see those questions getting answered. So thank you. So it's almost 7:15, so we're going to go ahead and reconvene the conversation and take up the Q&A at 7:20. I have 7:20 on my clock. Do we want to hop into the next slide and get prepped for the question and answer session?
Jason, when you're ready.
I was born ready.
Okay, we have the next next set of questions have to do with timelines for relocation modifications. They're all slightly different, so I'll ask each of them. From Rick R. and Wesley H. They ask, how long will it take to get approval for a relocation modification?
It depends. So it depends on what you mean by approval, and then it also depends on where you are in the DCR process. If you are an applicant and you no longer have site control, or you're unable to pursue a commercial cannabis activity at the location listed on your record, you can submit the business premises surrender form, which will then trigger the abandonment of the record. And if it's eligible for refiling, once we've updated the record to abandon-refile, that would give you the ability to initiate a refiling process and go through the pre-application review record again. If you have, once the record has been deemed abandoned and it's eligible for refiling, you have up to a year to go through the pre-application review process. So if you've already identified a prospective location, once the record's updated, you can immediately start that process, submit the new pre-application review record, pay the applicable fees, and then DCR would begin its review. If the location is deemed eligible for further processing, then of course you have up to a year to submit your application. And for the purposes of getting a license, it's really going to depend on whether or not you're in a position to, one, submit an application, and then two, pass an initial inspection and complete any equity share review that may be necessary for your record. So a lot of that's going to be applicant driven. If you've already gone through and created your legal business entity record and the equity share review has already been completed on it, that's going to reduce the processing time for you to meet the licensure requirements. For the purposes of the state, of course, once you've submitted your application and it's deemed filed, which means you paid the fees and you've uploaded all of the corresponding documents, then you get your status of local compliance underway. And if you're a social equity applicant, you would then have the ability to submit that to the state to pursue a state provisional license. And the state is still accepting applications from social equity applicants for new provisional licenses through March 31st. The director is prioritizing the phase 3 retail round 1, the phase 3 retail round 2, and these modification records, with the hope of getting as many social equity applicants to the point where they can pursue a provisional license as possible. Folks do have to submit their state application. You don't have to have a status of local compliance underway to submit your state application, because we have a completely bifurcated system from the state, but you will have to demonstrate local compliance underway within a few months in order to demonstrate to the state that you do have local compliance and you are eligible to receive your state provisional license. The state has until June 30th to continue processing social equity applications and issuing new provisional licenses. And then after that, everybody will be routed to the state's annual application process. If you are a licensee and you're requesting a relocation, once we've determined that your proposed location is eligible for further processing, we would create an application record for it, and you would have the ability to temporarily continue operating at your current location because it's licensed. And, you could cancel those licenses once you've met the licensure requirements for your new location. So the timing is really going to be dependent on where you are in our process and also what milestone you're trying to reach. So, are you trying to get your pre-app reviewed? That normally takes 30 to 60 days. Are you trying to go from pre-app to application so you can get your status of local compliance underway? That generally takes 30 to 90 days. It's really going to depend on what your end goal is.
Okay, our next question is similar, comes from Wesley H. And he asks, what is the timeline for different types of modification requests?
The ownership and primary personnel modification request take a little bit longer because for the ownership, it may require an additional equity share review or require your analyst to go into your operating agreements to make sure it complies with 10420. For the business premises diagram changes, those are generally fairly quick and just require another initial inspection if it meets the requirements. For the initial determination, I think we're going to be reducing those processing times by 20 to 30%. We've got a series of interviews for new staff over the next 2 weeks, and then we're going to be onboarding an additional analyst to help facilitate the licensing program. So also my supervisors have been redistributing the work and kind of identifying subject matter experts so that those folks are going to be focused on different application processes and modification types with the hope of onboarding new folks, getting them cross-trained into the different functional areas, but also providing better customer service and processing times. So this is a great question. Generally, I would say 30 to 60 days, but depending on the request and what has to go into it, it could take significantly longer. And then the last caveat is really if we don't have the documents before us, we can't do the analysis and work. So a portion of it is always going to be applicant driven.
Thank you, Jason. Stephanie R. is asking, what is the current processing time for modifications regarding ownership transfers and entity substitution?
Again, it's going to vary applicant to applicant, and it's going to depend on what their ultimate goal is. For ownership transfers, that's done on the legal business entity record. So if you haven't established your legal business entity record, you're not going to be able to submit a modification type. So every business needs to have a legal business entity record that is then linked to any of their applications and licensing records. So once it's updated, that modification gets pushed to all records, so it's consistent. The ownership transfers, of course, because they're no longer done on the licensing record, the ownership transfers won't impact the business's ability to operate, which is a good thing. For entity substitutions, of course, that's a completely different entity that is going to have to be verified and meet the licensing requirements, submit a new application before we're eligible to issue a license. The proposed entity is going to require their own legal business entity record. Once we've deemed it eligible for further processing, we create an application record for that entity, and then they need to meet the licensing requirements before they receive temporary approval or are eligible to move forward with an annual application. With the state phasing out the provisional licenses, the entity substitution and relocation is going to become difficult for general applicants because the state does require a new application when the legal entity changes or the location changes. So if you can't submit a provisional license application to the state, you're going to have to factor that into your business decision-making process, because if you don't continue with the existing entity or at the existing location, it could be a significant period of time that you're not going to be able to lawfully operate while you pursue a state annual license. So that's just things that folks are going to have to factor in as the state phases out their provisional licensure process. At the local level, we're going to be proposing a few new amendments to create a non-operational license type, which would allow for folks to continue with their local temporary approval for the licensed entity, while they go through the non-operational application for an entity substitution or a relocation so that they can hopefully meet the state's annual application requirements. And then, of course, once they've met those, we would have the ability to convert the non-operational to an operational, but you would at least have the ability to continue using the TA that has been issued for that period of time. We're also looking at an amendment to the Muni Code to allow for a license to be transferred. Under the current code, licenses can't be transferred. So anytime we're doing these entity substitutions or relocations, we're having to process a brand new application, which when we were only doing temporary approval applications, the bar was significantly lower than it's going to be for the annual application requirements. And then, of course, what the state's annual application requirements are going to be. So stay tuned.
Okay, I think this might be one of the last questions regarding timelines. It comes from AV, and he or she asks, for major modifications, how long is it taking for DCR to complete?
Generally, it's completed in 30 to 90 days. And that's processing time. It could be significantly longer, especially when it's a multi-step process, like an entity substitution or a relocation, where we do the initial review, we deem it eligible for further processing, an invoice gets issued, you've got 30 days to pay the invoice, and then we begin working on the actual request. It could take 6 months or longer, depending on the applicant's ability to move forward and how quickly they pay fees and get us information.
Okay, moving on, Timothy M asks, someone fraudulently submitted modifications on my behalf. What do I do?
I would recommend speaking with your analyst. And also, if they fraudulently submitted it on your behalf, most likely they could only do that if they had your user credentials. So I would recommend working with your analyst or going into the self-service portion of the portal to reset your password so they no longer have your password, so they can't get in and do things without your permission.
Thank you. Next question from John M. What are the limitations on moving to a new community plan?
So a license for cultivation and retail storefront or retail with on-site sales, those cannot be relocated to a new community plan area, even if it hasn't reached undue concentration. For activities that are not subject to a finding of undue concentration, non-volatile manufacturing, distribution, etc., we can just accept a new application within any community plan area that you want, because it's not, those activities are not subject to a finding of undue concentration. So we can accept an application anywhere within the city. For folks that are unable to move forward in their existing community plan area or at their existing proposed business premises location, once those records are deemed abandoned, folks have the ability to identify a new proposed business premises location in any community plan area that has not reached undue concentration. So abandonment refiling is the mechanism for applicants to move to a different community plan area. And then for licensees, it's going to depend on whether or not the activity is subject to a finding of undue concentration. Cultivation, retail with on-site sales has to be in the same community plan area. For something that's not subject to the finding of undue concentration, non-storefront delivery, non-volatile manufacturing, distribution, testing labs, we have the ability to set up an application anywhere in the city because, of course, we could just accept that application in the first place anywhere in the city. Hopefully that helps.
Okay, Craig W. asks, can a tier 1 sell their license to a company that can become a tier 3?
It depends on the record and what phase the record came in. So tier 3 is a construct that only existed on phase 2 records. That enabled businesses that were not social equity, but supplied a phase 1 existing medical marijuana dispensary, the ability to come in and get priority processing. Tier 3s do have a requirement to meet all of the different conditions and commitments under LAMC 10420. So if it's a phase 2 record, there is the ability to convert it from a tier 1 or a tier 2 to a tier 3, but the new business is going to have to meet all of the tier 3 commitments as they go into the annual application process. If it's a phase 3 retail round 1, phase 3 retail round 2, or other social equity record, you're not going to be able to, in air quotes, transfer it to tier 3 ownership, because tier 3 ownership is akin to general ownership, which means that it won't meet the equity share requirements, and it will be a modification request would be denied by the department.
Thank you. Hansel, you. Effective which dates are phase 3 retail round 1 able to change community plans and how?
So a phase 3 retail round 1 applicant that has had their application abandoned and it's eligible for refiling will have the ability beginning tomorrow to refile in a community plan area that has not reached undue concentration. So the refiling process that is in place is going to be the same process that's used to allow for retail with on-site sales to propose a community plan area different from the original one associated with their application record. So normal process, it's just now analysts will have the ability to, as part of their review, look at the proposed community plan area, determine if it's subject to a finding of undue concentration, and if not, we would have the ability to start the pre-application review record review for that refiled record.
Okay, our next question comes from Hansel U and Natalie D. Are sensitive use restrictions still the same or have they changed?
So the zoning and sensitive use distancing requirements haven't been updated or changed since July of 2021, and they're found under Municipal Code Section 105.
Okay, thank you. Cheryl B asked, what is the best way to reach a licensing analyst? What should I have ready when I call or email my licensing analyst?
So the most important thing is going to be, one, do you know who your assigned analyst is? And we're working on pushing that information to the DCR licensing portal so folks clearly know who their assigned analysts are. But if you email DCR licensing at illycity.org, it'll get to your assigned analyst. It just may take an extra day or two to get it routed, but you do need to have your application record number. So it's best for us to actually pull up your record and look at what phase it came in, whether or not it's a general or social equity record, verify that you're a contact on the record and what your role is, so that we have the ability to properly respond to your specific situation in question.
Okay, we have the following question from two people, Sam A and Rabin W. If I was allowed to leave one community plan, can I go back to the original community plan? And if so, how do I best make that change?
So if your original record is deemed abandoned, you would have the opportunity to potentially refile in a different community plan. You do have to propose a business premises address when you refile. If ultimately that location is ineligible for further processing or you're unable to get site control, we have the ability to close out that pre-application review record. And then we have to, assuming that you're within that 1-year period to refile, go back to the application record that was abandoned and re-update the status to abandon refile so that you would have the ability to refile another pre-application review record. If assuming your old CPA hasn't reached undue concentration, then you would be able to propose a new business premises in the original. However, if it has reached undue concentration, we would not be able to consider a refiled record in that same CPA. Or potentially we would not. It really is going to come down to what happens with some of the definitions and the proposals that we have pending before the Planning and Land Use Management Committee.
Thank you, Jason. Moving on, Sam A is also asking, can a social equity applicant be removed from an LLC and new owners added?
So if it's a social equity record, it has to meet the requirements under 10420 and the updated equity share review for us to process the ownership modification. So once a license has been issued, the qualifying social equity individual applicant may be removed provided their equity or a sufficient amount of their equity is transferred to another social equity individual applicant owner. And that's stuff that we would be looking at as part of the ownership modification process.
Our next question from Laheven J. What is the process to modify a partnership agreement once the original investor cancels the agreement?
So that would be something that would be updated as part of the legal business entity record. So operating agreements, partnership agreements, all of that is housed on that legal business entity record. So if you need to disclose updated agreements or new information, that's where you would submit the modification request. And then depending on the record type would depend on whether or not we had to conduct an equity share review in its entirety, or if we just have to charge the a la carte fee for the specific documents that are being updated.
Stephanie R asks, for ownership transfers, do we use the entity substitution record number or the application record number when submitting modifications?
So for ownership transfers, you'll use the legal business entity record where the owners are listed as contacts along with the primary personnel.
Okay. Shirag S, what is the process to move my license to a new location?
You would submit if your record has been abandoned and it's eligible for refiling, you would be able to propose a different location as part of the refiling process. If you have a license, then you would submit a modification request to relocate against your licensing record.
Shirag S also asks, what is the process to convert my manufacturing and distribution licenses to a micro license?
So at the local level, it wouldn't be applicable because micro business at the local level is a type of on-site retail license. So our local code requires you to individually apply for each activity and pay the corresponding fees that you're applying for. So micro business is akin to an on-site retail license locally. It has a different meaning at the state level. So based on the question, you would not be able to convert because neither of those licenses allow for on-site retail sales.
Thank you, Jason. Armin A is asking, can we modify an entity structure from sole proprietorship to corporation?
If you have a retail storefront license, you would have the ability to, well, if you have any license type through the entity substitution process, you would have the ability to convert from a sole proprietorship to a corporation. Depending on the license type and whether it's a general applicant or a social equity applicant, you may have to go through an equity share review or other ownership changes to do the conversion. Sole proprietors, of course, are 100% owners of the entity, so they go through the equity share review very quickly. Versus a corporation, we would have to review the bylaws, any operating agreements, any contracts that exist to determine whether or not it complies.
Royce B asks, how can I move my location before an inspection? Is this possible?
If you lose site control and you submit the business premises surrender form, the record could be deemed abandoned, which would allow for you to refile. Otherwise, passing the initial inspection is a prerequisite for getting a temporary approval license, and licensees are unable to relocate the license until the license is issued. So it really depends on where your record is in the process and whether or not you have site control.
The next question comes from Amir G. When are social equity applicants in abandonment expected to be able to relocate outside of their initial CPA?
So we'll be able to consider refiled applications and other CPAs beginning tomorrow. And of course, we'll be using the sensitive use data that's downloaded tomorrow to make those determinations about whether or not it's eligible for further processing based on that information.
Amir has an additional question. Are there options for applicants unable to secure property 12 months after abandonment?
There are not options under the current code. DCR has proposed a few different things that may, grant somebody who's unable to find a compliant property within 12 months some relief. But those are all proposals at this point in time.
Renee C asks, when will modification requests be implemented?
So the functionality to implement the two recent amendments to the Muni Code are already live in the DCR licensing portal, and we'll begin accepting and processing those modification requests starting tomorrow.
Great. Moving on, Joseph M. If I paid a modification fee of $542 to add a contact, for example, accountant, consultant, etc., to my license while they were employed by us, how do I go about removing said contact from my account/record? And then additionally, ideally, how do I go about this without paying the $542 fee again?
This is a great question. So the non-owner, non-primary personnel contacts are stored on the application or license record. And as part of our bifurcation, the creation of the legal business entity record for owners and primary personnel, and then of course the application and license records, the non-owner contacts can be removed from an application or a licensing record by submitting a other contact change against the application or licensing record. You'll use your LA-C or LA-S depending on what record type it is, and then entering the number, and then it'll give you option to just delete that contact and it won't trigger the 542. One of the things the director is trying to do is she's attempting to reduce the fees imposed against applicants and licensees. So her instruction has been to come up with different ways to create disclosure processes that don't trigger the fees. And this is one example where we've implemented that recommendation to eliminate the $542 fee to either add a non-owner contact like an accountant or consultant, or ultimately remove them from the record.
Okay, so the next question comes from Vishay T. We have a micro license, retail manufacturing distribution. We would like to split these licenses as individual and independent license activities. My first question is, how can we actually split the license?
Give me a sec while I think about my response. So my understanding of the question is entity A has 4 licenses and they want to basically separate the licenses so that the licenses are associated with different entities. You know, if they're going to truly different legal entities, then it would go through an entity substitution, whether or not the entity is a sole proprietor, an LLC, or a corporation. If you're trying to move the license to a different level 1 owner, that would be an ownership modification. The level 1 owner, of course, is the owner of the applicant or licensee. But if you're actually trying to change who the license is issued to, the only way to do that would be through the entity substitution process. We've had licensees have had the ability to bifurcate their licenses and separate them since 2020. So this is something that we already do that we're familiar with. It's just you're going to have to consider whether or not you're going to be able to get a state provisional license, or you may just want to reach out to the department to submit brand new applications that could go through the process separate and apart from something that may trigger a new application to be submitted to the state, which would require you to go through their annual application process. So just things for you to think about.
Okay, and then the second question from Vishay is, if we split the license and reapply, do we need a social equity applicant even though the license was pre-ICO?
So for the phase 1 licenses, there wasn't a social equity applicant component. So if there was an entity substitution request submitted, it wouldn't need to be to or from a social equity individual applicant. If there's a social equity owner on the record, it doesn't make the phase 1 licenses social equity licenses. They're just considered general licenses. If you submit a new application record, then you do have to meet, and what I mean by new is you're not submitting a modification request that triggers a new record being created. You're actually filing for a new activity. Then you would be subject to any of the social equity requirements that are within the code.
Okay, the next question from Tyrone F. How are modification fee invoices and payment reconciliation process between the Office of Finance and DCR?
So DCR is already working with the Office of Finance to implement the streamlined activity codes, and we've been transitioning folks to those new activity codes through the 2023 process. Once we get everybody converted over to 2023 records, we will turn back on the automated invoicing. But for now, we have to look at each record and determine what the applicable fees are and whether or not the correct codes are listed for that particular applicant based or licensee based on LA tax records. Once the invoice is issued, folks have 30 days to pay the invoice. And then depending on their method of payment, it could take a few weeks for finance to process the payment and notify DCR that the payment has been processed.
Okay, I think the next question is a repeat, but it probably bears repeating. It comes from Natalie D. Are community plans going to be allowed to be changed?
So applicants have the ability to refile in a different community plan area through the abandonment refiling process. For licensees, it depends on the license type and whether or not the license is subject to a finding of undue concentration. Unfortunately for licensees, Plum Committee did not accept the department's recommendation to allow licensees to relocate to community plan areas that have not reached undue concentration. So retail storefront and cultivation licenses can only be relocated within their original community plan area.
Okay, our next question from Sen A. Are we able to vote off an investor from the actual license if she owns less than 49%? If so, how?
So my first caveat is, we don't get involved in either private business disputes or a business's decision-making process. If somebody owns 20% or more of the equity in the applicant or licensee, they're considered an owner. And there's different ownership modifications. If their equity is being transferred to other existing owners, it's not considered an ownership modification. However, if their equity is transferring from them to a new owner, then it is considered a removal of an owner, which does require the owner's signature that's being removed. If you do get into a legal dispute, DCR would review any court orders that arise from that dispute, and we'll review the order, and if we can implement it based on our code, we would implement it.
The next question from Jesus P asks, is there a cost to a modification request?
Generally, yes. So a breakdown of the different modification and filing fees can be found under section 104.19H. There are certain modification request types, such as updating other contact types, your consultant, your accountant, the legal firm associated with your record or location. We are no longer charging the modification fee of $542. However, if you're doing an entity substitution, an ownership modification, a business premises relocation, or you're updating documents that have to be re-reviewed, there would be a corresponding fee.
Thank you, Jason. Michaela S asks, if a distributor is already operating but has 100% new owners, can a modification be done, or does that require a new application?
So with the creation of the legal business entity record, the modification can be considered against the legal business entity record as long as the entity is remaining the same. And because the modification would be on that record, it will not require a new application record for that commercial cannabis activity. And then of course, once we've processed the modification on the legal business entity record, we would just push those changes to any application or licensing records so that they're consistent.
Barry G asks, can a retail cannabis location move its location prior to social equity program applications being processed?
So there's two ways to relocate. Either you have a license and there's a set of rules for how those relocations can be considered and where folks can propose to go, or your record is deemed abandoned and you're eligible to refile. And then you have the ability to propose a new business premises location based on your refiling and whether or not the community plan area has reached undue concentration for the associated activity. But beginning tomorrow, we will be considering relocation requests and refiling requests according to the updated code. And then, of course, we've got over 100 applicants that have recently been deemed eligible to go through the pre-application review process and submit an application as part of phase 3 retail round 2. And those folks have every opportunity to begin that process and navigate through that process at their earliest convenience. So there's no way for somebody to jump somebody who is already in the queue or trying to move forward. So it's generally on a first come first serve basis.
David G asks, what modifications are available if an investor process stalls? Location and funding is not yet in place.
So if you've navigated through the pre-application review process and it's eligible for further processing, you have up to a year to submit your application. So, you have a year to resolve whatever business decisions you need to resolve before you submit your application. Once you've submitted your application, if you're unable to get to a filed application within 30 days, and we have the opportunity to provide cure periods provided you pay the additional fees, that could extend the time. But ultimately, if you can't move forward in our process, either because it stalls, you don't have site control, you're still making fundamental business decisions, it could result in the abandonment of your record, and that may trigger your ability to refile. And folks have up to 1 year from the date that their application is deemed abandoned to refile. So depending on timing, it could be as little as a year. It could be, a year and a half, 2 years, 2.5 years, just depending on how quickly you navigate from point A to point B and whether or not any abandonment processes are triggered.
Okay, the next question from Maximus S. Would a social equity applicant be able to add a partner corporate MSO on their license?
I mean, so it kind of, it depends on what their definition of the MSO is. So a management services organization, if you have the social equity applicant is a partial owner of the applicant or licensee, and equity is transferred to a corporation, regardless of what that corporation's role is going to be with the use of the license or management of the license, it could be done where the MSO is an owner of the applicant or licensee. And then, of course, they have the ability as an owner to be able to direct the operations of the business and be identified as a primary personnel of the license. If you're talking about a management services agreement and the MSO is going to be a management company that you're hiring to operate your business, the code does not allow a management company to be an owner. You're either a management company and you have no ownership stake, or you're an owner of the entity, but it's either or, and they're mutually exclusive. So it really depends on what role that MSO is going to play. Are they going to be an equity owner, at which point they're an owner and they can help manage the license? Or are they a company that you're hiring to manage your license and they're going to be considered a management company and they're not going to have an ownership stake in your business?
Okay, the next question is a two-parter. Let me know if you want me to stop after the first. If not, I'll read it through. Amir G asks, how can an applicant with an active application initiate the abandonment process to be able to refile? And then the second part is, can you highlight the process for social equity applicants to aggregate ownership when applying for temporary approval?
Okay. So the code outlines different reasons why a record may be deemed abandoned. I've talked about the business premises surrender form. An application or a licensing record is tied to a specific business premises location. So if you can't operate there anymore, that application is no longer viable. So that could result in abandonment. Folks may not pay fees. Folks may not submit information within the time provided by the department. That can all result in the abandonment of the record. Depending on the record type and when it is abandoned, it may be eligible to refile. You know, as I mentioned previously, a record that is abandoned and then refiled is not that refiled record itself is not eligible for refiling, which is why, you know, we have to go back and reactivate the original record, provided that there's still time on the original 1 year that you have the ability to refile. And that's all stuff that you'll have to communicate directly with your analyst on. For the second part of the question, it's not a change in the process from a system perspective for the aggregation of social equity individual applicant ownership. It's just you would list the additional social equity individual applicants, the social equity owners, on your temporary approval application documents that get uploaded to the legal business entity record. And when we'll verify that those owners are in fact verified social equity individual applicants. And then two, we'll add up their ownership or their equity within the applicant or licensee to determine if it meets the requirements under 10420. So for existing applicants and licensees, you can submit a modification request to change the ownership of the legal entity to give you the ability to reflect aggregated ownership, or on new records, when the applicant is creating the legal business entity record or modifying the existing legal business entity record, you would just submit updated ownership documents that reflect who the additional social equity owners are and what their equity stake is. Now, for aggregation purposes, you may need to list people on those documents that don't rise to the level of being considered an owner on the record. So to be considered an owner, somebody has to have a 20% or more equity stake. But there's nothing wrong with an SEIA having a 5% or a 10% equity stake. But if you may need to disclose them and their equity stake, even though they're not an owner, to basically give us enough information to determine that the aggregate ownership is associated with social equity individual applicants and meets the requirements. So again, you can aggregate at something less than the equity necessary to be considered an owner. You just need to disclose everybody who has the equity and is a verified SEIA to meet whatever the equity share requirements are for your particular record type. And I hope that helps.
Thank you. Our next question comes from Ron B. When refiling, can you make all your changes, or do you need a modification request after refiling?
That's a tricky question. For the legal business entity record, you have the ability to modify owners and primary personnel. And of course, we can do a new equity share review for that record. For refiling, if it's a general application record, it has to be refiled as the original entity. If there's multiple social equity individual applicants that aggregate their equity to meet the equity share requirements, it has to be refiled as the original entity. The only time a record could be refiled as a different entity is when there's one social equity individual applicant and they have the ability, using their authorization either through round one or from round two, to propose a different legal entity. Anybody has the ability to propose a different location. However, when we look at the new proposed business premises location, we'll be looking to determine whether or not, one, the community plan area is subject to a finding of undue concentration, and then two, whether or not it's properly distanced and zoned.
Okay, our next question from Alice L asks, how do you remove a partner from a licensed business?
You would submit an ownership modification request. And depending on how you're facilitating the removal of the owner, whether their equity is transferring to other owners or their equity is going to somebody not listed on the record, will kind of drive the documentation that you need to submit to the department.
Okay, the next question from Richard V. Can a phase 3 retail round 1 submit a business premises relocation into another community plan where a current pre-ICO MMD already exists if all parties agree?
And give me a second, that was a complex one. So if a phase 3 retail round 1 record was deemed abandoned, it could be refiled into a different community plan area that has not reached undue concentration. So assuming the CPA where the phase 1 business is located is not unduly concentrated, there would be an ability to submit a new pre-application review record for that community plan area. If you're either trying to backfill where the phase 1 business was or propose a location within 700 feet, that business would have to surrender their location, or DCR would not be able to deem the location eligible for further processing. So if the phase 1 business was also looking to relocate, it would kind of be an order of operation game where they would also have to submit their relocation request. It would have to be deemed eligible for further processing. They would have to either cancel the license at the existing location to remove the PIN, which removes the buffer so that your pre-application review record could be deemed eligible for further processing and you could pursue it, or they would have to move forward with licensure at another location, and at some point we would remove the PIN associated with their old location. To the extent that you're in communication with them and you're kind of lining up the dominoes so they all fall into place, that would work. But if you're contemplating somebody is going to move and they choose not to move, and we haven't facilitated the move yet, we won't be able to consider your pre-application review record or deem it eligible for further processing.
Thank you for that, Jason. Shauna Marie asks, if an owner/partner needs to go away, but an original owner is staying, what forms are needed besides the modification form?
So if the applicant or licensee is not changing, you would submit an ownership modification against the legal business entity record. Whether or not an original owner is staying really isn't going to matter. We're still going to need updated ownership forms to reflect how the equity is spread and who the owners and primary personnel are. And, if the original owner's equity is going to somebody who is not currently listed, we'll need the removal of owner form executed from them. If it's going to existing owners, again, it's not considered an ownership modification, and we wouldn't need the removal of owner form.
Okay. Rabin W. When will we have, sorry, let me try that again. When will we be able to move from our present community plan area, and what areas are we able to move to?
If your application is abandoned, you will have the ability to refile in a community plan area that has not reached undue concentration. Currently, 5 or 6 of the community plan areas are considered unduly concentrated. Those are all CPAs that were considered unduly concentrated coming out of phase 1. And, as we issue additional licenses, additional community plan areas could reach undue concentration. The CPA is really going to be driven by where you're looking, and then of course what the underlying zoning is and the distance of the proposed parcel is to any sensitive uses. But the majority of the CPAs can be considered, because only 5 or 6 of the 35 are unduly concentrated at this point in time.
Okay, the next question is a repeat, but I'll go ahead and ask it from Laura A. How can I remove an owner?
You'll have to submit an ownership modification against the legal business entity record.
And Laura is also asking, how can I, as a social equity member, separate myself from my partners?
So we don't provide business advice or get involved in business disputes. We can consider ownership modifications that are submitted to the department, provided a modification request is submitted. If you have a business dispute, you may want to seek legal advice.
Okay, Dana Lee is asking, we have submitted ownership change requests in the past that were not done. Can we recoup those fees and ensure our next request is processed? How do we find out who is our assigned analyst?
You can email DCR Licensing at lacity.org to find out who your assigned analyst is. And your assigned analyst can provide you a status of any previously submitted modification requests.
Okay, so Paula B is asking, is licensee relocation only permissible within the same community plan area? And when will this be changed?
So for license type subject to a finding of undue concentration, retail storefront, anything with on-site retail sales, cultivation, DCR does not have the authority to allow the licensee to relocate to a different community plan area. We have proposed a recommendation that would enable the relocation of a license to a CPA that has not reached undue concentration, but that recommendation is still pending with the Planning and Land Use Management Committee. And I honestly don't know if or when that recommendation would be adopted, but it would require an amendment to the municipal code for non-volatile manufacturing, distribution, testing labs. Those activities are not subject to a finding of undue concentration. So, in most cases, we could just accept a new application for where you want to relocate to. And then once we've processed the application, you could choose to make the business decision to cancel or not renew a previously issued license. But for things that are subject to the findings of undue concentration or are limited to social equity applicants, we don't have the flexibility to that.
Okay, Michael A asks, can you currently relocate an operating retail license in the city of LA?
A licensee for retail storefront may request to relocate within their existing community plan area. Please be advised that if you are not a social equity applicant, you will not be able to pursue a new provisional license for your new location, which means that you would have to stop operating until you receive your state annual license, which would also require you to receive your city annual license. So if you are looking to relocate or change, you do have to factor the change in the state's processes and licensure requirements into that calculation, because you may lose the ability to operate for a significant period of time.
Philip C asks, can I transfer a social equity license to a different community plan?
Now, again, whether it's a general license or a social equity license doesn't change whether or not you can go to a different community plan. It's the activity type that will drive that, and whether or not that activity is subject to a finding of undue concentration.
Luis R asks, does a modification request need to be submitted to update an owner from regular owner to a social equity program owner if they are if they were verified during the past round as a social equity applicant?
So provided they're already listed as an owner on the record, when we review the 2023 record or the updated record, their social equity status will be reflected next to them. So we'll know that they're a social equity owner, and then the analyst that's either reviewing the application or reviewing the renewal application and legal business entity record associated with it could go ahead and just change them from owner to social equity owner. And it doesn't trigger a modification fee. It's just changing the associated Excel title for that person.
The next question from Luis R. Can a modification request be submitted for unapproved PCN for ownership change and or relocation?
No, PCN requests are all site specific. And if the PCN finding was not made, the record was denied by operation of law and that record is closed. Or if you are planning to pursue a new public convenience or necessity finding, you could go ahead and create the legal business entity record for the entity that would be pursuing that opportunity. And then you would have the opportunity to do any updated ownership changes and stuff on that record. And then of course, when the PCN process reopens, you would just submit a new pre-application review record for that community plan. And then once we determine it is subject to a finding of undue concentration, that PCN request would be transmitted for council consideration.
Okay, and our final question for tonight, thank you, Jason, is from Maurice C. Where is DCR's plan to accommodate existing cultivation licenses now that the limitation on medium cultivation licenses have been lifted by DCC?
I mean, at this point, DCR is bound by the municipal code, which limits folks to 1.5 acres of aggregate cultivation space, which is equivalent to 3 medium indoor licenses used at the 22,000 square foot limit of the license type. So right now, an applicant or licensee is still bound locally to the equivalent of 3 medium cultivation licenses. So unless the limitation on that license type is lifted locally, we're not going to be able to consider additional multiple cultivation licenses or combinations of large and medium licenses that would exceed the 1.5 acre threshold.
Thanks, Jason. That's it.
I really appreciate you staying late and the team for staying late to support this, and for everybody who has stuck around for the entire presentation. So thank you everybody for joining tonight. The next Q&A session will be on Wednesday, February 15th at noon. So feel free to RSVP and remit questions in advance for that session so that we can add them to the list, and they'll be taken care of first when we get to the Q&A. And then please check our website for the Zoom links and the RSP form, and have a great evening. Thank you all. Have a great night.